Hi, everybody. Thank you for coming. This is our presentation on water administration and water rights. We have another presentation that we give that's more focused on well permitting and real estate transactions. This one is more focused on the basics of water rights and how DWR administers water in Colorado. I'm Wenley Dickinson with the State Engineer's Office, and I have Emily Pauley here from the Attorney General's Office. Thank you everyone for coming. We have a lot of people online, so I just wanted to say really quickly that unless you're speaking, make sure to mute yourself just to make sure that there's not feedback or a lot of background noise. Oh my gosh, that's... And also, if you have a question, we're just going to ask people to hold the question until the end of the section, and then we'll try to get to those. At the end, we'll have some time for Q&A to try to maybe dive into some topics that we glossed over. If there's anything during the presentation that we don't get to for the people online or the people in the room, if you have a really specific question that we weren't able to answer, we would really encourage you to call us or submit an Ask DWR because we are going to cover a lot of broad topics and may not be able to get to your question. And just double checking, if anyone can't hear us very well online, please say something in the chat and we'll just make sure that the audio and video is good. I'll go ahead and get started. We'll give a background on DWR, water administration in Colorado, what water court is, and what water court does. We'll have a really brief section on the Groundwater Commission, the different statutory types of groundwater, and a really brief section on well permitting and exemptions. We have some FAQs at the end. We might not have time to get into those, but if there's a question during this time, we can certainly go to those slides. Okay, so DWR is one of many agencies within the Department of Natural Resources with the state of Colorado. We have Avalanche Info, Forestry, Mining, Energy and Carbon Management Commission, ECMC, Parks and Wildlife, State Trust Lands, Water Conservation, and then our office, which is the Division of Water Resources. Our major responsibilities are water administration, public safety when it comes to well construction and dam construction oversight. We issue well permits to use water. We are also involved in interstate compacts and maintaining compact compliance with other states. We have a hydrography program that does flow measurement, and then we also have public information services. So like presentations like this, we have an info desk line where the public can ask questions. So there's different avenues that we like to try to educate the public. This is a really brief breakdown of water administration or water usage in Colorado. Primarily, water is used for agriculture. About 86% of water is used for agriculture in Colorado. Then is municipal and domestic uses, recreation, industrial and commercial, recharge, and augmentation. And we will talk about augmentation a little bit later in this presentation. There are a lot of water rights structures and wells. So we have close to 180,000 water rights in the state. We have over 105,000 structures, and structures can be like head gates, they can be ponds, reservoirs, and then we have over 280,000 wells. And these numbers are fairly recent in the last year or two. One thing I do want to point out is that we have more water rights than there are structures, and that can be because a structure could have multiple water rights on it. Like an easy example that I would think of is a reservoir might have multiple users, multiple water rights that are being stored in that reservoir. I'm just gonna... We are the headwater state, a headwater state. If you're probably, most of you are familiar with that term, but that means that The water that originates in Colorado falls as precipitation or snow. It flows out of our state into 19 other states as well as Mexico. And that's the reason why we have a lot of these compacts with 19 other states. And I'm just going through this really quickly because I do want to get to the kind of meat and potatoes of what we really want to get into. But again, if you have questions on kind of this background information, we can talk about that later, or you can submit a question to us later. So the Division of Water Resources Authority is granted in statute, and I just highlighted a few key statutes here for you guys to reference, and I'll go through these somewhat quickly. So we have the sole authority to administer, distribute, and regulate waters of the state. We can adopt rules and regulations to assist in our duties. So that's sometimes it can get complicated when you're looking at statutes and rules and policies, or maybe local rules as well. Those all play a part. Examples would be well use rules in the South Platte Basin, for example, or well measurement rules that are in place in multiple divisions. We curtail junior water rights or water waste. Water commissioners can also access structures for measurement purposes. So that's sometimes a question we get from the public, or comes up when water commissioners are doing their job, is can they come onto my property, which is private property, to access this measurement device? They can, and that is in statute. We can provide an opinion on whether a water supply plan for a subdivision can cause injury. So that's something that comes up a lot too when people are developing land or they want to create a subdivision. We provide an opinion on their water supply plan. And we also have administrative approvals, and we're not going to talk about all of these, but they're listed here. A really common one is a temporary substitute water supply plan, which can operate like an augmentation plan, but rather than being approved by the water court, it's an administrative approval by our office. Some others are in-stream flow loans, interruptible water supply agreements, exchanges, and some other administrative approvals in other divisions.
So I'm just going to cover some key statutes that are important for administration in Colorado. So you'll see 3792-501, that's kind of like the general just jurisdiction to administer water that we have within Colorado. And then daily administration housed in 502 that talks about discontinuing water supplies. If it's not available, that will be called or curtailed, and we'll go more in depth with that in a little bit. And then again, what Wendy just said about staff may enter private property under that. So that's kind of part of that. And then 3784-117.5, release of water to account for EVAP from on-stream reservoirs, and then exchanges and administrative exchanges that Wendy just talked about too. So just some basic vocab when we're talking about water administration generally. Adjudication is just judicial confirmation of a water right. So that's when you go to water court and adjudicate that water right. So you go get a decree for that. A decree or ruling is that judgment issued by water court for confirmation of your water right. Appropriation are the specific actions or act taken to begin the water right process. There are a couple criteria you have to meet there, but generally we just call that appropriation. That's the starting point of putting that water to beneficial use. Acre foot is a measurement of water. You may also hear cubic foot per second, but acre foot's kind of generally what we use to like quantify maybe reservoir rights, how much is delivered in storage. So that's just an acre foot. If you think of an acre a foot high, that's what an acre foot is. And then curtail, if we have not enough water to go around, which is often the case, water rights will be curtailed so that we can get water to senior water users. And then a head gate is a structure used to divert water off of a stream system, often measured there as well. Some additional vocab, conditional water rights and absolute water rights. So there are two types of water rights in outside of designated basins, outside of the Denver Basin. So it's kind of not applicable to those areas. An absolute water right is water right that has been perfected, it's been put to beneficial use, whereas a conditional water right is still in process. So you may have started to appropriate that water right, taken a step to do that, maybe gone to court to get that recognized, but it hasn't actually been put to beneficial use yet. So we have what's called diligence filings on conditional water rights, and that has to be done every 6 years. If not, that water right could be lost or abandoned. Abandonment, if water rights are not exercised every 10 years, they may be put on the state abandonment list, and then those water rights are lost, you can't get them back. So pay special attention to those. We just did a decennial abandonment, and that'll be coming up in a few years, so just pay attention to your papers and making sure if you have a water right, you're paying attention to that. Some key statutes again. So everything is housed in Title 37 of the Colorado Revised Statutes. And then there's different articles within that. So Article 92 is the General Water Rights Determination and Administration Act. It's how we get all of the process for water court, for how we really authorize these water rights, how we go through it, any exempt well permitting, which is a little bit different than regular well permitting or well permitting within side and outside designated basins for the Denver Basin. That's in 3790 of the Colorado Revised Statutes. All of the state engineer responsibility and authorities are within Article 80, including enforcement actions if water is being misused or used incorrectly or illegally. 3784 is responsibility that water users have for maintenance of ditches, no waste, making sure that we're having measurements in place or measurement structures in place, very important for administration of water rights. And then 3787 is reservoir administration. So just a little bit of background for why we operate this way. Colorado is very dry. I think we all know that. We have a very arid state. We originally came here with miners back in the day. They used water for mining and also for domestic purposes for settlement. As we got more and more settlers here, as our state started thriving more, we ran into issues with water wars, water conflicts. And so it made the necessity for an actual administrative system to be put into place. It was also housed in our Constitution that we're going to be under a prior appropriation system. So a priority system where water must be put to beneficial use. And it was how we are saying if you were here first, then you get to use the water and so forth. And so you can kind of see the difference. This map illustrates like what water systems look like in the United States, and you can see a harsh divide there in the middle of the country. Those are basically all the states on the right are relying on the Mississippi River. They're very wet states. They're more riparian, so water rights are tied to their proximity to rivers and streams. Whereas in the West, if it's not strict prior appropriation, it may be a mix of prior appropriation, riparian, or have a history of prior appropriation or riparian that's kind of changed over the years. You can see some very strict prior appropriation states, Colorado included, and then some mix along in the West. Again, that's just the nature of the geography, the geology, and us being a headwater state and where water is actually at in the West. So again, the Constitution of Colorado identified that water is owned by the public, it's owned by the state, it's a usufructuary right. I'm terrible at that word, I'm sorry. But it's a concept where you have a right to use the water. You don't own the water itself. You don't own the water molecules. You just own the right to use it in your bundle of property sticks. So it can be sold, traded, bartered. That right to use can still be given away, but you don't own the right to the water itself. But it must be put, the water right is a usufructuary right that must be put to beneficial use. That's very important in having a water right. It's identified as part of the water right. And then these water rights are also granted in priority, meaning if you were here first, you're a senior water rights user that adjudicated, appropriated your water right, you get to use the water first, and as opposed to someone who came here in 2018 who got a water right much later, they're going to have a more junior priority, senior first, then junior. So I talked a little bit about beneficial uses. These are some identified beneficial uses in Colorado. They change sometimes, but these are generally it. Irrigation, commercial, ag, muni, industrial, fire protection, fish and wildlife, domestic and livestock, recreation, snowmaking, and then augmentation replacement can be used to replace auto priority diversions. It's an exception to the prior appropriation system. And then in-stream flow rights, which can only be held by the Colorado Water Conservation Board. There's also sometimes some questions about exchange and storage, if those are beneficial uses. These are not beneficial uses. They are a means to put water to beneficial use. So they can be in decrees, they can be in applications, but they're not a beneficial use in and of themselves. Just some important dates. In 1881, going way back to when we first started getting prior appropriation system created in Colorado, the Office of the State Engineer was created in 1881 to help administer these water rights in the prior appropriation system in priority. 1957, well permits were then required for certain types of wells. 1965, the Groundwater Management Act created the Groundwater Commission, which we'll talk about in a little bit, and designated basins, which take up most of the eastern half of Colorado. In 1969, the legislature confirmed and codified the connection of surface and groundwater through the Water Rights Determination and Administration Act. And that's why they're administered together, why augmentation plans started coming into play. And then 1985, Senate Bill 5 created the statewide non-tributary rules for withdrawal and administration of non-tributary groundwater. So this is just an illustration of the prior appropriation system, first in time, first in right. You can see the stream flow has 100 CFS. You have a junior that has a right for 50 CFS and a senior who has an 1860 right for 70 CFS. So if there's not enough water to satisfy the 50 and the 70, which there's not, there's only 100, that water is going to bypass the junior and go to the senior. The senior gets all 70 CFS and remaining can go to that junior, to the rest of that 30. So they wouldn't get the full extent of their right if there's not enough physical supply in the river, unless they have an augmentation plan, which we'll talk about in a second. So just clarifying what adjudication, appropriation, how this all works in the priority system. Prior to creation of the standing of water court by that 1969 act, the adjudication date is the date respective of district court adjudication. So if you're first to file, you're first in right. If you don't get a decree from water court, you don't have standing in the priority system. So that's super important to adjudicate your water right. So for example, I think it's easier to just see an example of this rather than read through that slide. Let's say you have an upstream neighbor who irrigated a field since 1910. Your neighbor has never filed an application with water court, but then you or I diverted water from that same stream to irrigate a field in 2020. And then I filed an application with water court that year, let's say in June of 2020. Then my neighbor got wise to it, decided to adjudicate their water right, but didn't file until the next year, till 2021. But I would have that senior date. My water right would be senior because I filed that water right first. If they never filed an application in water court, they wouldn't even be in the priority system, couldn't be administered, and I would have the senior right. However, if that same neighbor, when I filed the application in June, then filed an application in November, you would have the same adjudication date, and the neighbor would be senior because they appropriated the water right first. So one thing I also referenced a call. So generally when there's enough water, it's called free river. That goes, everyone gets their right, no one's curtailed. We all get our water underneath our water rights. We put it to beneficial use. But when there's not enough, a senior will put on what's called a call on the river so they get enough water. So if we think back to that example before of the juniors only getting part of their water right, senior gets all of it, that's because there's a potential call on the stream. They're calling for all of their water right. Junior only gets a little bit. If there are any more junior rights on that stream, they wouldn't get any at that time until more water became available.
I want to take a second and see if anyone has any questions or if there were any questions in the chat. If you have a question, you can drop it in the chat, or if anybody wants to raise their hand. I just want to take a breather and see if we should keep going or if there's something that we can clarify for anyone. Nope. Okay, well then we will keep going. And of course we'll have questions at the end as well. So we want to talk about over-appropriated versus critical areas. It's helpful that Emily just talked about what a call is. So over-appropriated areas are areas where there is not enough water to satisfy the demands of all of these decreed water rights. So we have a map here where divisions 1, 2, and 3, which are the South Platte, Arkansas, and Rio Grande basins, those are all over-appropriated. So wells in this area might need an augmentation plan because there's essentially kind of a year-round shortage of water, that there's just not enough water to meet everyone's demands. We also have critical and non-critical areas on the west slope. So these green areas are non-critical, and I didn't update this map this morning. There's a portion in the Yampa that is critical. I would go to our website for the most up-to-date map, or go to our map viewer tool for the most up-to-date information. But basically, if you're in these critical areas, these are also areas where there's senior users calling for water, and they're essentially over-appropriated, and you would need an augmentation plan for certain types of wells in these areas as well. And then there's very limited areas on the west slope in green here, which are non-critical, where water is available for appropriation, and you would not need an augmentation plan. Really quick too, for people who are not familiar with the Public Land Survey System, or PLSS, we just wanted to provide this slide for reference. When you're reading decrees or a well permit, you might see language that looks like located in the northwest quarter of the northeast quarter of its section, township, and range. Those locations are referencing this Public Land Survey System. All of the U.S. is divided into a bunch of squares that use these directions. So it's kind of how we describe land and how we describe where water rights would be located. A lot of people are probably more familiar with latitude and longitude. Water rights and well permits might use distances from section lines, which are also a coordinate system. It's just a different way of describing a location. I think this dates back to Thomas Jefferson. It's a very old system, and is also why when you're flying in a plane and you're looking down at cropland, everything seems to be in squares. It's because the land was basically plotted and sold and divided into these squares. So next we want to talk about how the prior appropriation system works for all water in the state. So basically, all surface water and groundwater is presumed to be tributary. Tributary meaning that there's a connection between surface water, a connection between this water and rivers, and would be administered under the priority system. So a stream or creek that you have, or a spring, that water has a hydraulic connection to a major river and would be tributary and administered in that first in time, first in right system. There are exceptions to this though. So non-tributary groundwater is water that does not have a significant connection to surface water, so that would not be administered under the priority system since it's non-tributary. We also have certain statutory exemptions, such as exempt well permits. So these are your residential or domestic wells that you might see on land that is 35 acres or more, where somebody doesn't have a water right, they don't have an augmentation plan, and they don't have an appropriation. It's because they have this exemption that's carved out in statute. And there's some other exemptions, such as stormwater detention ponds, or recently stream restoration activities might be exempted from this system. Next, we want to talk about non-exempt wells. Non-exempt wells are not exempt from the priority system. They have to be administered together with tributary water, surface water. And this slide is just to talk about non-exempt well administration. As I said, they are required to be administered in the priority system because of that connection they have with surface water. And the way I explain this to people who sometimes don't have a technical or engineering background or a background in water law, if you're pumping your well and your well's a mile away from the river, sometimes people have a hard time imagining, well, how is pumping my well affecting the river? It does, maybe slowly over time. Maybe you pump your well today, and in 30 days, that impact is felt on the river, and there's less water in the river nearby because of that connection. Because of that, wells in overappropriated areas have to be augmented. So that's providing that replacement water to prevent injury to senior water rights users. And an issue with wells is that if I pump today and somebody says, oh, you're out of priority, stop pumping your well, I could stop pumping my well today, but those depletions, the effect of that well could tail out for days, weeks, months, maybe, or years even. So wells can't be administered the same way as surface water, where you just curtail a well and tell them stop pumping, because of that lagged effect on surface water. Any questions on that before I go to the next section? Any questions online? If you want to drop them in the chat. Any questions from anyone in the room? You guys are all experts. Okay, so next I'll talk about how groundwater is defined in statute. So we have this graphic here to show tributary surface water, which is, I think, the easiest to understand. This is a stream or a river here. It's tributary because it's got that connection. We have tributary groundwater. So here's this shallower, unconfined aquifer here. And it's also tributary because there's a connection with surface water. So there's an ability for water to move between this river and the aquifer, or maybe there's precipitation and that water percolates down into the aquifer. There is definitely a connection between groundwater and surface water. So both this tributary surface water and tributary groundwater are administered in that priority system. We also have non-tributary groundwater being shown here. So there's this confining layer right here, that's that dark brown, that's preventing significant movement of water between this confined aquifer and the aquifer above it, or surface water above it. So this groundwater, if I pumped from this well, maybe one of these wells that's constructed into this non-tributary aquifer, it's not going to affect surface water. We're not going to see an impact on the surface from pumping this non-tributary well, which is why these non-tributary wells would be administered outside of the priority system. So the Denver Basin aquifers are basically geological formations that are layered on top of each other along the Front Range. They are non-tributary aquifers, so they're administered separately. They are administered under the Denver Basin rules and the non-tributary rules. And that's because of their lack of connection here. So if you're, let me show, maybe it'd be easier to talk about this with the map. If you're in this area and you've got a well or a decree that's for one of these aquifers, being the Dawson, Denver, Arapahoe, or Laramie Fox Hills, your well is not going to be administered the same way. Your well is going to be administered based on a land ownership and a 100-year aquifer life based on the rules. So you can kind of see the extent here. It's mainly along the Front Range, and then here's kind of showing the layers. So the Laramie Fox Hills is the largest extent here. And then we have the Dawson sitting on top. It doesn't extend the full area, so you might be in, depending on where you're located, some of the Denver Basin aquifers might exist, maybe only one, maybe none of them if you're outside of this. So we just want people to be aware of this special area that has its own rules. I apologize for the amount of text on this slide. We did want to go into the definition of non-tributary and not non-tributary. So I did talk about non-tributary having little connection with surface water. The actual definition of non-tributary is in statute, which we've cited here. The definition is that if you withdraw this groundwater, it will, within the first 100 years of withdrawing that water, it will not impact surface flows greater than 0.1% of withdrawals. So that's that threshold, is that 0.1% or 0.1% of pumping. And if you, in order to be considered non-tributary groundwater, you have to be subject to the Denver Basin rules, so be in one of those Denver Basin aquifers, the produced non-tributary rules, or if you have a decree or a determination by the state engineer that your groundwater is non-tributary. So there's a couple different ways to get a determination that the groundwater is non-tributary. Absent a decree or determination or rule, the groundwater is presumed to be tributary. Then we have not non-tributary, which I kind of think of as like a semi-tributary, semi-non-tributary. It's kind of this in-between and is specific just to the Denver Basin aquifers, where there's still not a lot of connection to surface water, but I'll just kind of paraphrase the definition here, that withdrawal will, in the first 100 years, cause depletions greater than 0.1% of pumping. So it's still a confined Denver Basin aquifer, but it has a greater than 0.1% impact. Not non-tributary groundwater withdrawn from non-exempt wells does require an augmentation plan because of that greater than 0.1% impact. It's a little different from tributary groundwater though, because you only have to replace the impact from pumping or 4% of depletion. So Denver Basin augmentation plans would look a little different from tributary augmentation plans because the replacement requirement is different. And then we have designated groundwater. Designated basins are, as Emily said, out on the eastern plains. They are administered differently because they have their own rules and are subject to the Groundwater Commission as opposed to the Water Court. This is just to try to compare tributary versus non-tributary versus not non-tributary side by side. So if you get confused about tributary, not non-tributary, and non-tributary, they're all kind of here with these bullet points. I did email everyone the slides, but if for some reason you didn't get them or you want a copy, you can just email myself or Emily and we can send you the slides. And next we'll talk about Water Court.
I should have clarified at the beginning that although I'm at the Attorney General's office, my statements and opinions do not reflect Attorney General Weiser. They are my own. But that being said, we'll go into the Water Court slide. And this is not legal advice. I'm just describing generally what the Water Court process is like. I can't give you legal advice, but we can answer just general basic questions about it. So basically, Water Court is the court that oversees water matters. So there's district courts, and Water Court is a type of district court, but it's specialized just for water matters. That's where you go to adjudicate those water rights that I was talking about earlier when you want to get a decree and get in the priority system for those water rights. The DWR cannot confer or confirm a water right itself. That can only come from the power within a water court. So it is the system for surface water, rivers, ditches, springs, reservoirs, and groundwater. There are 7 of them throughout the state of Colorado, and each one sits in each division, the 7 divisions of Colorado. You have a water judge and then a referee and a clerk. A referee is still a judicial officer, but it is who takes first look at a water matter most often. They help just remediate any issues, just kind of get through the water court process. So a water referee has their own docket. Sometimes those cases go back to the water judge, but generally the cases go to the referee first. That is the map of all of the divisions, and so each one sits in each of the divisions. So we have Water Court in Greeley, that's in Division 1. Water Court in Division 2 is down in Pueblo, and so on and so forth throughout the divisions. So if you have a water right that you want to adjudicate in these areas, that's the water court you would go to apply to for your water right and get your decree from. So if you had a a ditch you wanted to adjudicate or a well you wanted to adjudicate and you were in, let's say, Colorado Springs, you would go to Division 2. If you're in Kiowa, you would go to Division 2. So you just have to go to the geographic area to go to your relevant division water court office. So those applications can be done pro se, meaning you don't have to have an attorney to go through the process. Some of those simple applications are really easily done through a pro se process. Some of them, like augmentation plans or changes of water applications, can be a little bit more complicated, and that's when attorneys may want to be involved. It's up to you. You can totally decide that, except if you're a corporation, you have to have an attorney in water court. Water court applications, if you want to see kind of generally what those look like, what they consist of, they can be found online at the water court's website. I think it's like judicial.state.water. I don't know. We can always send that to you if you have questions, but it's really easy to find online. There's a whole list of them, objection forms, all the different types of applications, and those can all be just filled in and sent to the clerk, and they can help you through that too. So basically, the general process of a water court application, you file that application, pay the fee to file that. That application then gets published in Water Court Resume or Resume Review. That's also published in the relevant papers. So if you have a water right that is in Jefferson County, it's going to be published in the paper that's published in Jefferson County. Same with Adams County, so on and so forth throughout the state. The water court then, if the Division of State Engineers do not file what's called a statement of opposition to your application, the water court, the referee, will consult with the division engineer to talk about if there's any questions or factual issues with the application. And then you can enter a draft ruling with the referee. That will be entered. There's an objection period for the ruling of referee, and then the judge will sign the final decree. If there are statements of objections, this can really elongate the water court process. It can go anywhere from 4 or 5 months to several years. I think I just finished a case that was filed in like 2002. So it just really depends. It depends on the referee process. It depends on the judge that's sitting in the water court, and then how those settlements negotiations are going. Oh, and this is kind of a graphic of that. So you can see at the beginning of it, the applications are filed. They're referred to the referee. Parties can also ask them to re-refer back to the judge. If they go back to the judge, that's when cases go on litigation or trial track. So you have a lot of deadlines that you must meet during a trial track timeline under the Colorado Rules of Civil Procedure. But if it stays before the referee, those deadlines don't really come into play. We're just kind of working through comments on your application, your ruling, any issues that objectors have, you work through those, and then eventually get to a decree. Again, it can be a very quick process if you don't have any statements of opposition. I think when I was in private practice, I got one done in like 4 months. There's some statutory minimums in there for timelines, but again, it can also take several years. So this is kind of just a graphic of fees. I don't know if we have, I don't think this is updated, right, May 2024, but an application to adjudicate a water right, if you are in, want to adjudicate your well or have like a ditch you want to adjudicate on your property, it can be a very quick process just depending on where you're at, $200 plus publication fees. If you have an augmentation plan that's required that Wenli was talking about earlier, that can be a much more expensive process. Change of water rights, exchanges, more of these convoluted, complicated applications. It costs a little bit more, about $400 or so, $500. And then if you want to object to any applications you see that are published, that's about $200 to file that. So there's a myriad of costs and different fees, but it's all listed. I don't think they change too much from year to year. It's pretty standard. This is kind of what it's been for a little bit. So, but just something to keep in mind when you adjudicate those water rights. So in those applications for water rights, you must have all of the basic elements of a water right. It's fundamental to having that bundle of sticks that for those law students or lawyers on the call, really important to keep those contained. So what you have is your description of your structure, whether it be where you're diverting from the river, what the diversion is, spring, well, reservoir, a pond on your property, whatever, and then the source feeding that structure. The date of appropriation, so the date that you started to develop that water right or the date you diverted that water right, you must have that as well. Where it's actually diverting from, whether it's from an aquifer, groundwater, or from a stream system, how much is being diverted or stored, so back to that CFS and acre foot amount, and then the specific beneficial uses that are tied to that water right, and where they're placed to beneficial use. So augmentation plans. These are a way for you to get out of the priority system. It's an exception to the priority system. You can essentially divert water that is otherwise entitled to a senior water right user, place it to your beneficial use, but then you must provide replacement water to that place that the senior water user would be entitled to receive that water. So there's a little bit of a graphic. I think that would be helpful while I'm talking about this. So here we go. You have so much on the river. It's going to a junior water right over here, but that junior water right is then providing replacement water that's then going to these senior water rights users. So if there would normally be not enough water, there would be a call in here or curtailed. You couldn't go to this junior water right user, but because they have a decreed augmentation plan providing replacement water, these senior water rights users still get their water and they can use it as well. So basic elements of an augmentation plan, you have to have a description of the structure. So if you're augmenting a well, like a non-exempt well, if you're augmenting a diversion from a stream system that's out of priority, and you also must include the replacement water source. There's lots of different replacement sources. It can be from shares and lakes or reservoirs, other groundwater sources, municipal supplies sometimes come into play, and then how that replacement water is being provided to the stream system or to the point where the senior water user would be entitled to receive their water. So we need to have a detailed operation plan so that the state engineer and division engineers can actually help operate and administer the augmentation plan. And then measurement, accounting, reporting requirements. So how are you measuring your water that's being diverted? How are you measuring the water that's being put back? When is that happening? Are you submitting that timely? So those would all be in a decree and part of the augmentation plan. Then any other conditions that are necessary to protect senior existing water rights. So they may have some specific things like certain amounts that have to stay in the stream system, like flow amounts, anything like that, that they would work through those issues with you in our augmentation plan. So I referenced a change decree earlier. So can decrees be changed? Yes. You can apply to water court to amend augmentation plan, to change historical water rights. It's much more complicated than just an application to get a water right adjudicated originally. So that requires some dry up, an evaluation of historical consumptive use, historical return flows, and there's some other terms and conditions that are a little bit more nuanced to how that water was used previously before it was changed, where it was used previously before it's being changed. So it's a much more detailed analysis, but yes, water rights can be changed.
We have a question online that's actually pertinent to this slide. How long can municipalities hold on to water rights that they have purchased from ag and are not putting them to beneficial use before changing them to municipal use in water court?
So if you're holding onto a water right, not putting it to any beneficial use, there's a couple of nuances there, but they could potentially be abandoned if they're not being used. So that's part of something to consider. So decennial abandonments are every 10-year abandonments. So
would we say maybe 10 years of non-use, it could be abandoned, so you don't want to be exceeding that?
Right. I would say try to keep it under the 10-year. Again, there's a couple of nuances there, but definitely within the 10 years is what my non-legal advice is.
Awesome.
Let me change the slide for you, sorry.
Okay, so we touched a little bit on designated basins. I want to talk about the Groundwater Commission, which has jurisdiction in the designated basins. I'll show this map again just to remind you that in all of these areas that are not shaded in, that are white here, the water court has jurisdiction. So if you want to get a water right or change a water right, you would apply to the water court that's in your division. If you're in one of these shaded areas because you're in designated basins, the Groundwater Commission has jurisdiction. So the commission would be approving water rights. So we have a summary here of what the commission does. They administer groundwater within the designated basins. We have a little bit more about designated basins. They are on the Eastern Plains and they have very little surface water. Users in that area rely primarily on groundwater, and in my head, that's kind of why they're different, is because they don't have all of the surface water supplies that we have outside of designated basins and on the west slope. There's the groundwater within designated basins is designated groundwater, but you could also have water that is designated groundwater that's within the Denver Basin. There's 8 designated groundwater basins, and some basins might also have groundwater management districts that were formed. There's 14 of those, and those management districts might have additional rules or regulations on water usage within that area. So that's another layer of complexity, is you've got the designated basin rules where the commission administers those, and you might also have some additional rules from management districts. And the commission can approve water rights, changes to water rights, similar to the water court. They also can approve replacement plans, which are similar to augmentation plans. They provide replacement water to prevent injury to existing water rights. They just have a different terminology, and the replacement water is being provided to the alluvial aquifer. Since there's not a lot of surface water, you're not making replacements to surface water in designated basins. The commission has delegated a lot of its responsibilities to DWR staff. So if you have a well permit application in designated basins, if you have an application for a water right or to change a water right, those would be evaluated and processed by DWR staff within the Denver office. And Emily had gone over absolute and conditional water rights earlier. Designated basins doesn't have absolute and conditional water rights, but it has a similar concept. So a final permit is kind of like making a water right absolute, where you perfect the water right. You've shown that you've put the water to beneficial use within the first 3 years of getting your well permit. So you have a well permit, which is kind of like a conditional right, and then you get the final permit once you've perfected the water right, which is the absolute water right is kind of like a final permit. There's no diligence requirement in designated basins like there is outside of designated basins. So outside of designated basins, you'd have to file diligence on a conditional water right. But inside designated basins, there's not a diligence requirement, but there might be a requirement to file a statement of beneficial use showing that you've used the water. And I already talked about this, but replacement plans are analogous to augmentation plans. They're similar in concept, though the way that they're applied for or worded is going to look pretty different. Something that's tough in designated basins is finding a replacement source, because they rely primarily on groundwater. Finding a replacement source to replace your well pumping depletions could be really tough. Outside of designated basins, someone might use a changed irrigation surface right or a release from a reservoir, but designated basins doesn't have like this giant network of surface reservoirs that they can use as a replacement source. So that's one thing that's a little bit different about replacement plans inside designated basins.
A couple of questions we can get to.
Yeah, we can get to that at the end. This is our last slide before we go to questions or dive deeper into any topics that people want to talk about. This is just a handy comparison of Water Court, Groundwater Commission, and our office. So Water Court and the Groundwater Commission are both adjudicatory bodies that have jurisdiction over their respective areas. The Groundwater Commission is also regulatory. And then our office, separate from that, we administer those water rights. And I'm sure most people in the room and a lot of people online know this, but I do sometimes have to make the distinction that we administer those water rights. We can issue well permits, but just reiterating, we can't approve water rights, we can't change water rights if you're in an area where you need to apply to the water court. Here is our contact information. So we've got our website, our Ask DWR online form. That's a really great way to ask a question, especially if you have some documents, if you have a complicated situation and you want to provide all of those details. This is a really great way to ask us a question. You'll get a response in a few business days. Here's our records section. So if you're looking for a well permit number or you're trying to research some records, you can call our records. We also have our groundwater information desk that's open Monday through Friday, 9 a.m. to 4 p.m. If you have a groundwater related question, really common questions are trying to locate a well permit, trying to figure out whether a permit is valid or what a well can be used for, or just general questions about how groundwater might be administered in your area. And in-person meetings are by appointment only. But I really want to highlight our Ask DWR online form because I saw some questions with some of the RSVPs that were really specific. And I apologize that we can't answer those during our presentation just because there's so many questions. But if your question wasn't answered today, I would suggest submitting that Ask DWR. Yeah, feel free to email us your questions though, because it sounds like you have a lot of questions and I definitely want to answer them all. But also want to be respectful of everyone's time here. I think since people are hopping off and I don't see any other questions, I'm going to call it. Thank you everyone for coming. Hope to see you in May for our well permitting presentation. Again, please email us or call us if you have any questions. Thank you.
Thank you.
Awesome.
You're fine, you're fine.
All right, I'm going to leave this meeting.